Educational Service. My name is Baron Rodriguez, and I am the Director of the Privacy Technical Assistance Center, or PTAC. With me, Michael Hawes, the Statistical Privacy Advisor at the U.S. Department of Education.
Good afternoon, or I guess for those of you on the West Coast, good morning.
Before, I'd like to cover a few logistical items with you. First, lines have been muted. This is so all participants can enjoy the webinar without the crackling of phone lines or the inevitable elevator hold music. We're having interactive polls to get to know the audience. We look to your input. The recording of this webinar will be made available on PTAC's website in approximately 1 week. In order to simplify this presentation, limitations are not in the webinar, however, will be available within the official guidance document. If you have questions, put them in the lower right-hand corner of the webinar window. At the conclusion of the webinar, we will have a moderator answer a few select questions. We may be able to answer all of your questions, either due to time constraints or simply because we don't know the answer at this time. So our first poll. I'd like to know who is in the audience. Please from the following choices in the poll. K administration, K-12 faculty, post-secondary administration or faculty, education and technology industry, or such as a nonprofit organization or parent or student. The landscape of technology is difficult to keep up with at best. PTAC, the department, recognizes that there is a need for more guidance around protecting student privacy in an electronic age. Remember that FERPA was enacted well before the preponderance of electronic data files and student information systems. As such, FERPA is very unclear around the protection of electronic student records. It's trying to discuss high-level guidance to help schools, districts, service providers, and others to navigate the best practice considerations for protecting student privacy. Remember that there are legal protections for student information used online, and you should consider state, local, and tribal law protections of student information as well. Finally, it's important to think beyond simply being compliant with FERPA. We also recommend employing best practices in addition to compliance requirements such as PPRA and FERPA.
To give a background, just wanted to share a brief quote from Secretary of Education Arne Duncan that he gave at a event a couple weeks ago. He must provide our schools, teachers, and students with cutting-edge learning tools, and we must protect our children's privacy. We can and must accomplish both goals. I think that's a quote to keep in mind.
Tech is everywhere in the education community. Some examples of technology in schools that may contain or use, or these are some examples of technology in schools that may contain or use student personally identifiable information, or PII, information systems such as Pearson or eScholar, productivity applications such as Google Apps for Education or Microsoft 365, educational applications such as teacher dashboards, and fundamental school services such as school transportation services or cafeteria services. Guidance relates to the following subsets of education services such as computer software, mobile applications, web-based tools that either are provided by a third, accessed via the internet by students and or parents, and are used as part of a school activity. This guidance is not covering online services or social media used in a personal capacity, or those that are used by the district in an administrative function that are not accessed by parents or students.
Changes in the computing and telecommunications sectors over the last couple decades. We see corresponding shifts in these technologies used in the education sector. This is to a number of new privacy and data governance challenges that some districts have had to address. First, the growing complexity of many of these technologies, coupled with budgetary constraints, has led many schools and districts to contract out a greater share of school functions rather than performing them in-house. As this move online and as technology advances, we see new types of data that are being collected and a whole lot more of it overall. Many online services are also increasingly using a take-it-or-leave-it terms of service agreement, often called a click-wrap agreement, instead of the two-party written contract model used in more traditional contracting relationships, which are new challenges that we'll talk about later in the presentation. Faced with these developments, our challenge is to find a way to leverage the tremendous potential of these new technologies and data in an effective and appropriate way without compromising students' privacy. So, to that end, what role does the U.S. Department of Education play in protecting student privacy? Most importantly, we administer and enforce a number of federal laws governing the privacy of student information, including 2 laws that we'll be talking about today in the context of using online educational services. The Educational Rights and Privacy Act, or FERPA for short, Action of Pupil Rights Amendment, or PPRA. But, administering and enforcing these laws is all that we do to protect student privacy, that keep our Family Policy Compliance Office very busy. We work to raise awareness throughout the education community of privacy risks and challenges involved when collecting and using student data. We provide general and targeted technical assistance through PTAC on privacy and security issues to schools, districts, and states, and we are active in promoting a number of privacy and security best practices that we urge education stakeholders to adopt.
Now we take a look at the answers to the first poll. Comment and open that up. And we have quite a mix of folks out there. Specifically, it looks like the majority of folks are in the K-12 administration, and a lot of others that are out there in some of the other specific areas that we had mentioned. So thank you for completing that poll. We're going to go to the next poll now. We'd like an idea of your expertise with FERPA. First suggested answer is FERPA. What's FERPA? The second is, I know it to be dangerous. And the you add me to your national cadre of experts on FERPA. I'm an expert. We'll look at that poll in just a moment.
So, I'm talking about FERPA. Simply put, FERPA guarantees parents access to the information contained in their children's education records and protects those records from unauthorized disclosure without the parent's consent. More specifically, FERPA gives parents the right to access and seek to amend their children's education records. The law protects any personally identifiable information, or PII, from those education records from unauthorized disclosure, and there is written consent from the parent before sharing PII with third parties, unless an exception applies. And there are a number of these exceptions to FERPA's written consent requirements, and sat through any of our prior webinars are undoubtedly familiar with some of them. In this discussion, we're going to focus exclusively on 2 of these exceptions, the free information exception and the school official exception. But as I said, there are a number of other exceptions to this consent requirement, and we'll link to the PTAC website at the end of the presentation if you want to find out more information about any of them. So, Baron, can you tell us about these 2 exceptions to FERPA's consent requirement?
Sure. We know students don't attend school anonymously. FERPA allows schools to release certain information without consent. Schools include name, address, email address, photographs, degrees, awards received, such as valedictorians. Keep in mind that much of this information could be PII, and just because you can do it doesn't mean it's a best practice. In addition, remember that schools must provide the list of what they consider directory information in annual notification to parents, and that can opt out of that information being shared. Sources of this exception are yearbooks, student registries, and concert programs. Remember, that parents have the right to opt out. School exception is generally the exception that allows those involved in the education of students to be able to deliver education services needed to the student. When involving a third-party provider, or TPP, it's important the following caveats are met. First, it has to be a service or function that the school or district would otherwise use its own employees. For example, this could be a student information system services provider or dashboards provided by a vendor. Secondly, the data by that TPP is under direct control of that provider with regard to the use and maintenance of education records. Third, the use of data aligns with the annual notification sent to parents on what constitutes a school official with legitimate educational interest. And the data cannot be used for unauthorized purposes. Should we go to our?
Yeah. So let's second and see what we had as a result from our last poll on how well you all know FERPA. Like most of you, enough to be dangerous. That's the vast majority of you. A few haven't heard much about it before. Some of you think you're experts. So that's good to hear. You're in good company. Another quick poll here, and kind of rate your familiarity with the PRA. Options here are yawn, I know all about it. I've worked with it, but only in regard to the survey provisions. I have knowledge about PPRA, or oh, wait, that stands for Pen Pal Research Association. So please take a moment and fill that out so we can gauge your background. All right, the PPRA has been around for many years. Its notable changes, for the purpose of today's discussion, though, were introduced with it when it was amended as part of the No Child Left Behind Act of 2001. The law is mostly known for its provisions dealing with surveys in elementary and secondary schools, the so-called sex, drugs, and rock and roll provisions. It also includes limitations on the use of personal information collected from students for marketing purposes. Subject to certain exceptions, including a notable one for education products and services, the PPRA also has requirements on parental notification and parents the opportunity to opt their children out of these activities.
So Michael, is student information used in online educational services protected by FERPA?
As much as I wish I could give a definitive answer to that question, and as much as I appreciate those on Twitter who recently poked fun at us for saying it in the guidance document, the real answer to that question is it depends. Used in online educational services is absolutely protected by FERPA. For instance, student profile information like name, grade, and email address that a school enters into an online system to create students' user accounts. When that information is taken from education records, like the school's student information system, that would absolutely be implicated. But there are many different types of online services and even more types of data, much of which isn't protected by FERPA. Take, for instance, an online portal that students use to watch tutorials or complete interactive exercises without logging in or using individual accounts. In these cases, no PII is involved, so FERPA does not apply. In the schools and districts will typically need to evaluate the use of online educational services on a case-by-case basis to determine if FERPA-protected information is implicated.
What does FERPA require from PII from students' education records is disclosed to a provider?
The most straightforward approach would be to have the parents provide written consent for their children's information to be disclosed to the service provider. But anyone who has ever tried to collect field trip permission slips can attest this is often not an efficient process and may be unworkable for essential services that are central to the education process. In parental consent, disclosure PII from education records can only occur under one of FERPA's exceptions to the consent requirement. In the online educational services, this will likely be done under one of the two exceptions we discussed earlier. The direct information exception is an easy way to disclose student information to create student accounts, but only if all of the data elements that will be disclosed are properly designated as directory information in the school or district's annual notice. Also, using the directory information exception may be problematic in those cases where parents have elected to opt out of directory information. It is unfeasible for a school to maintain two separate systems for the same function, an online one for the majority of students and a paper-based one for those students whose parents have opted out of directory information. Because of the complexities of using the directory information exception, either because of the data elements involved or because of the parental opt-out option, FERPA's official exception to consent is often the best, or at least the most efficient, option to disclose information to third-party service providers. As mentioned before, however, using the school official exception, there are a number of requirements that must be met. First, the provider must meet the school or district specified criteria for school official with legitimate educational interest, as stated in their annual FERPA notice. The use of the PII must be for authorized purposes only and under the direct control of the school or district. And this is where the third-party provider will be creating or maintaining education records for the school district must ensure that parents retain the right to access those records, directly from the provider or more likely from the school or district who obtains them from the provider.
Under and PPRA, are providers limited in what they can do with the student information they collect or receive?
And I'll have to say it depends. In this case, it depends how the information was collected or disclosed. If the PII was disclosed under the directory information exception, then typically there would be no other limitations on using the data for other purposes. If information was disclosed under the school official exception, on the other hand, then the PII may only be used for the specific purpose or purposes for which it was disclosed. Third providers are prohibited from selling or sharing the PII or using it for any other purpose except as directed by the school or district and as permitted by FERPA. But not FERPA-protected information is implicated. Whenever personal information is collected from a student, the PRA may also apply. So the PRA's restrictions on marketing may apply even when there are no other legal protections on the data. The rest, though, FERPA and the PPRA represent minimum legal requirements. They are the floor, not the ceiling, when it comes to protecting students' privacy. Schools and districts can and often should consider placing additional limitations on what online service providers can do with student information by inserting those provisions into their agreements with the service providers.
Michael, I hear the word metadata thrown around quite a bit. What is it? And are restrictions on what providers can do with metadata about students' interactions with their services?
So, very right. Metadata has been used a lot in the news recently, and those who use the term have not done a very good job explaining what it actually means. Put simply, metadata are pieces of information that provide meaning and context to other data being collected or used. For example, if we were interested in tracking a student's performance on a particular online activity, or as is more often the case, trying to find patterns in how a large number of students perform on a specific activity, we want to know how the students did on the activity, the data. This information would have a whole lot more meaning and analytical use if you also knew the date and time the student performed the activity, the number of attempts they made, how the mouse hovered over the answer button, which could indicate indecision on their part, or what changed their answer before submitting it. All other pieces of contextual information, collectively known as metadata, are really useful for education technology developers in building and enhancing their underlying algorithms used in personalized learning and other similar technologies. Metadata have been stripped of all direct identifiers, and other indirect identifying information are not protected under FERPA, because at that point they are no longer considered to be PII. An important caveat, however, that looking to de-identify metadata, it's important to consider that, depending on the context, school name or other geographic information can be indirect identifiers in student data. People often forget that point. Done properly, though, de-identified metadata can be used by providers for a number of other purposes, otherwise prohibited by law, or more restrictive data use provisions in the provider's agreement with the school or district.
There are other laws to consider, such as COPPA, with the Children's Online Privacy and Protection Act, which applies to commercial websites and online services directed to children under age 13. This law is administered by the Federal Trade Commission. Please link for more information. Now I'll walk you through several best practices on protecting student privacy. The first, which we just discussed, is that it's critical to be aware of other relevant laws such as COPPA that may apply. Also be aware of your local, state, or tribal laws. In fact, many states and local entities have pending or passed laws regarding the protection of student personally identifiable information.
Administrators will also want to be aware of which online educational services are currently in use in your school or district. Thus, in protecting student data is know what information is being collected or shared, by whom, and for what purposes, and even begin to answer these questions and to know what services are being used across your organization.
It's important your organization has policies and procedures consistent with state, local, and federal law to evaluate and approve proposed education services. For instance, you may have a policy that requires that any new software must be reviewed by legal, information technology, and management prior to being implemented in a classroom setting.
So, on that subject, can individual teachers sign up for free, or as they call them, freemium education services to use in their classrooms?
Well, let me say nothing is free. In many cases, from Facebook to groceries frequent shopper card, identifiable information or marketing information is in your payment for the service. It's important to remember that FERPA has requirements, which we discussed earlier, that you must adhere with when using these types of software or applications. Remember that many apps can introduce security vulnerabilities into your school networks. Most importantly, we consider best practice to have regular trainings with staff around your policies regarding the use of software, downloads, and free services.
Good. Getting back to our list of best practices to consider, though it does not expressly require that schools or districts use a written contract or legal agreement when disclosing information under the school official exception, we strongly recommend that schools and districts do so whenever possible. Not only do these agreements help with the direct control requirements we discussed earlier, but they also serve to clarify the use restrictions and other legal requirements the provider is expected to meet.
Transparency is critical when it comes to communicating with parents and students on how data is being used, who it's being shared with, and for what purpose. We highly recommend that school districts inform parents of how children's data is being used, what information is being shared, and for what purpose in a public forum as a website.
And lastly, while in circumstances where obtaining parental consent is just not feasible, hence FERPA's exceptions, many other circumstances where obtaining parental consent is the best way to go. Going that route is a great way to increase transparency about your school or district data use. Many districts are doing it to communicate with parents about what their kids are doing online. So that it's not always an option, but we do recommend it whenever possible.
My decisions should be in a school's or district's contract with a provider.
Good. FERPA does not expressly require that schools or districts use a contract or written agreement with a third-party provider. But for the reasons we've discussed, it is absolutely a best practice to do so, and a number of provisions that we recommend including in those agreements when you develop them. First, we recommend including data security and data stewardship provisions. Clear whether the data being collected belong to the school or to the provider, and describe each party's responsibility in the event of a data breach. We establish minimum security controls that the provider should use, and for auditing of their compliance with those controls. recommend clearly specifying what information the provider will be collecting through their service, whether logs, cookies, using tracking pixels, or whatever it may be. It's hard to assess and mitigate the privacy risk of a technology if you don't even know what information it's collecting. Define the specific purposes for which provider may use student information, and then legally bind them only to those approved uses. How will the provider hold on to the data in identifiable form? Will they be permitted to share it with any other party? Ends, how do they handle destroying the data? All these are important terms to consider laying out in a written agreement. We recommend specifying whether the school, district, or parent will be permitted to access the data in the system. If so, the process for obtaining access. This is particularly important if the provider will be creating or maintaining education records for the school, as FERPA's access rights would then come into play. We recommend establishing how long the agreement will be in force and what the terms are for modifying, amending, or terminating the agreement, and particularly important for reasons we'll talk about in a little bit. We recommend considering whether there should be or should not be any provisions wherein the school or district indemnifies the provider or vice versa, clearly as it relates to the school or district's potential liabilities resulting from failure to comply with federal, state, or tribal law.
What online educational services that use click-wrap agreements instead of traditional contracts?
As I mentioned before, click-wrap agreements are a particular form of legal agreement between the service provider and the user of that service. Essentially a compilation of take-it-or-leave-it legal provisions established by the provider to which the user agrees by clicking accept. Not using these provisions means not using the service, plain and simple. Well, these click-wrap agreements pose a challenge for the use of online educational services because they muddy the waters a bit about how the various legal requirements and best practices will be met. Consequently, we recommend that schools or districts take extra caution and apply extra scrutiny to these agreements before accepting them and using these services. Schools should be sure to check the amendment provisions. Click-wrap agreements allow the provider to unilaterally change the terms of the agreement without notice to the user. Give FERPA school officials exception requirement to maintain direct control over the use of student information. We recommend that schools and districts exercise caution when agreeing to any terms of service that allow for amendment without notice. And to enter into them, we recommend reviewing the agreements regularly to determine if any provisions have changed. Printing or saving any terms of service agreement that you accept. Remember, legally binding agreements between vendor and the school or district. You should be sure to keep a copy for future reference. And because these click-wrap agreements are legally binding documents between the provider and the school or district, and they are so easy to agree to with one quick click of a mouse button, we recommend that districts or schools establish policies that specify who has authority to accept terms of service agreements and would be reviewing these agreements prior to accepting them.
Next, link to the latest guidance document. And while it's rather lengthy, if you just go to ptac.ed.gov, it's right of our homepage and the recent updated articles. Key sources that may be useful to you that relate to the guidance document that we put out, we encourage you to go there as well.